Hi there, podcast and public radio fans. Heath Drusen here, host and creator of the Extremely American podcast. I'm working on season 3, which is an urgent story about neo-Nazi terrorists and how they helped build a modern white supremacist movement, even from prison. Some of their ideas have even made it to today's White House. It's both a gripping true crime story and a timely warning about threats to our democracy. And this time, my investigative reporting is funded by you. To support the project, please make a tax-deductible contribution at extremelyamerican.org. That's extremelyamerican.org. And thanks.
More Idaho Matters now from the studios of Boise State Public Radio News. I'm Gemma Gaudette. The 14th Amendment contains just one sentence on citizenship, but that single sentence has been at the center of a national debate for more than a year now. Birthright citizenship. This is the idea that most people born on U.S. soil automatically become U.S. citizens, has long been considered a bedrock of American law. But President Trump's executive order seeking to limit birthright citizenship has reignited questions about what the Constitution actually says, what the framers of the 14th Amendment intended, and how much power a president has to reinterpret a constitutional guarantee. The U.S. Supreme Court heard arguments in the case this spring, and it is expected that the court will issue a decision that could have major implications for immigration policy, as well as presidential authority and the meaning of citizenship itself. So to help us understand what's at stake, we're joined today by McKay Cunningham, graduate professor and director of the Master of Applied Public Policy program at the College of Idaho. McKay, it's always nice to have you on the show.
Thank you, Gemma. Good to be here.
So can we just start with the basics? What exactly does the Constitution say about birthright citizenship? And furthermore, McKay, why has that language been interpreted the way it has for more than a century?
Yeah, the 14th Amendment clearly says the following, and I'll quote it: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And that has been memorialized in our Constitution ever since 1868. And Jim, I think it's fun when we talk about constitutional law issues because there's so many provisions in the Constitution that are not clear. Whether it's due process or equal protection, those are big, amorphous words, and there's a lot of room for the Supreme Court to interpret them. By contrast, this is one of those provisions in the Constitution that seems to be pretty clear. All persons born in the United States and subject to its jurisdiction are citizens of the United States. I think that answers the second part of your question. That's the reason that we have, for well over 100 years, understood those words to mean what they say, which is, if a child is born here on U.S. soil, then they're a citizen, full stop. But the executive order issued by the president on his first day in office, the second term, seeks to change that.
So, McKay, my understanding is the key phrase in the 14th Amendment, and you said it, is that subject to the jurisdiction thereof. Why has that phrase become the focal point of this legal fight?
Yeah, great question. Subject to the jurisdiction thereof has been interpreted by the courts for several decades to mean if you're in the United States and you commit a crime, then you can be prosecuted for the crime. You're subject to the jurisdiction, to the laws of this country. And the traditional understanding by the courts of what's subject to, why include it if everyone who is in the United States is subject to its laws? Because some people aren't. So diplomats or consuls or ministers of foreign countries who come to the United States representing their country oftentimes have limited immunity from U.S. law. And so diplomats have traditionally been understood to be living in the United States, but not subject to the jurisdiction of the United States. And so courts have, over the decades, identified that subject to the jurisdiction thereof means that there are some people, like diplomats, who are not in fact subject to our laws, even though they are living within the boundaries of the United States. The same goes for some sovereign Indian tribes, at least up until 1924, because they were deemed to be sovereign or semi-sovereign, they were deemed not to be subject to the jurisdiction thereof. And so children born within those tribes did not have birthright citizenship, at least up into the early 1920s.
Mm-hmm. So my understanding is that supporters of the president's executive order, they're arguing that the Constitution has just been interpreted too broadly. So McKay, what's the legal argument they're actually making there?
Yeah, the legal argument is twofold. I mean, to oversimplify a little bit, I will say it's twofold. The first portion is that the 14th Amendment, according to Trump's lawyers, was very specifically directed towards previously enslaved people. I mean, it was ratified in 1868, just a couple years after the end of the Civil War. And the argument is that this birthright citizenship provision was really targeted. The purpose was to make sure that previously enslaved peoples would become citizens. And so the second part of their legal argument, aside from that narrow purpose, is to say, subject to the jurisdiction thereof, that those 5 words in the 14th Amendment, subject to the jurisdiction thereof, means something like allegiance, such that if someone is traveling through the United States on a tourist visa, they're just here temporarily, and they happen to have a child, according to President Trump, subject to the jurisdiction thereof means allegiance. And these people who are here temporarily, just traveling through the United States, do not have any allegiance to the United States, and therefore should not be given the benefit of birthright citizenship.
So then opponents say the issue was settled long ago, both by the Constitution, but also by Supreme Court precedent. So what precedent are they talking about?
The primary precedent relied on by opponents to the president's executive order is called Wong Kim Ark. It was decided over 128 years ago, and it's a case that is interesting because there was 2 people of Chinese descent. They were not U.S. citizens, but they were of Chinese descent living in California. They had a child. The parents left and went back to China. The child stayed within California, grew up, went to visit at some point back to China, and then tried to re-enter the United States. And at that point, the citizen or the person was denied. And that led to a Supreme Court case. And the Supreme Court said, hey, look, it doesn't matter that this person's parents were not citizens. This person was born in the United States and gets the full benefit of birthright citizenship. And so that case is 128 years old. It is directly in conflict with the president's executive order, because the president's executive order says, among other things, that children born to people who are in the United States and are undocumented do not get birthright citizenship. This case, way back in 1898, says the opposite. So you're right. I mean, okay. One of the most interesting things about this case that it's going to drop any day now, Gemma, is the amount of precedent and the clarity of the language in the U.S. Constitution are really pretty stark. So for the court to rule otherwise would be a bit of a change for the rule of law and a bit of a change for stare decisis.
So you mentioned executive order, McKay, and I think one thing that can be really confusing sometimes is the role of an executive order. So can a president actually change the practical meaning of a constitutional provision through an executive action alone?
Short answer is no. I mean, just full stop, no. And that may very well change when we hear from the Supreme Court in the next couple of days.
So how unusual is it then for a president to really try to alter a longstanding understanding of citizenship without Congress first passing a law?
It's pretty unusual. I mean, I would say, Gemma, that even if Congress passed a law that did the exact same thing that the president did with regard to his executive order, it would meet the same result in the sense that it violates the fairly clear provision of the 14th Amendment. In other words, the only way to materially change birthright citizenship in the United States is through a constitutional amendment. So neither Congress nor the president can unilaterally materially change a clear provision of the U.S. Constitution.
So I want to go back to when the when the oral arguments were made back in the spring. When the justices heard these arguments, in your opinion, what seemed to be the questions that most concerned them?
First of all, I'd like to say that this was the first time in the history of our country that a sitting president attended oral arguments.
Hmm.
I think that that's kind of gone under the radar a little bit. This is an instance where the president has issued his own executive order, and that is the central issue in the case in front of the Supreme Court, and the president attended in person. But to get to your question, the most of the argument really centered on what we've discussed a little bit already, and that is what does subject to the jurisdiction thereof. The president's lawyers really emphasize that subject to the jurisdiction thereof should mean something akin to allegiance, or it should be something akin to legal domicile. In other words, birthright citizenship, yes, it still exists, but you have to also show that there is some allegiance on the behalf of the parents or some legal domicile on behalf of the parents before that birthright citizenship can be conferred.
So I'd like to know your thoughts on this. Is this case really about immigration policy? I mean, or is it more fundamentally just about constitutional interpretation as well as presidential power?
Wow. I think that, I mean, a lot of commentators have suggested that the reason for this executive order is really aimed at illegal immigration, so that there
Hmm.
is a practical purpose to the executive order. Many of the arguments that they made in front of the Supreme Court was that birthright citizenship, as we do it now in this country, is a perverse incentive. Like, we are incentivizing people to come to our country without documentation, illegally, knowing that if they have a child, that child will be a US citizen. And so a lot of the arguments made by the president's attorneys were along those practical lines. The flip side of that, I think, is pretty interesting. If President Trump's executive order was given the green light by the Supreme Court 25 years from now, we would have, according to the Migration Policy Institute, we'd have 4.7 million people in the United States who were stateless. In
Mm.
other words, 4.7 million people who were born to people who were either here legally on a temporary visa or here undocumented. Those 4.7 million children would be stateless, and would, I think, create an underclass that would be very difficult for those people to get out of.
I think there's also some confusion on birthright citizenship in regards to we've heard that, and I believe the president has said something in regards to, we're one of only a handful of countries that have birthright citizenship. When it comes to broad automatic birthright citizenship, if I've done the numbers right, we have about 33 countries that do that, including the United States. About 59 countries have some sort of birthright citizenship. So it's not necessarily automatic. So this is not an uncommon thing. And the reason why I bring this up is that if the court sides with the administration, who would be immediately most impacted, McKay?
The people who would be immediately most impacted would be mothers about to give birth, especially if they are here legally but on a temporary visa or are
Mm.
undocumented, and of course their children. I think beyond that, the infrastructure that would have to be put into place by hospitals, by federal agencies, by a whole range of different departments in order to implement this, I think would be pretty dadgum complex and difficult in order to enforce this executive order were it to become law. I agree with your point, by the way, Gemma. There are lots of countries that have what I'll term as unconditional birthright citizenship, like the United States. That would include Canada, Brazil, Mexico, Argentina, Chile, etc. But there's also a lot of countries that have conditional birthright citizenship. And I think there's some
Hmm.
good arguments that maybe the United States should go in that direction, but going in that direction by a unilateral executive order that cuts pretty clearly against clear language in the Constitution is perhaps not the way to go about that objective.
So if the court rejects the executive order, would that settle the issue for good? I mean, or, could a future administration or even a future Congress continue to challenge birthright citizenship?
I think that it would settle it for the time being. I mean, I think that, I don't know, a lot of academics were surprised that this executive order came from the president in the first place, because like we've been talking about, this has been settled law for well over 100 years. So to say that someone wouldn't challenge settled law again, I'm sure that's a possibility. In fact, just in 2025, I believe it was Senator Lindsey Graham, who championed a statute. It did not get past both houses, but that statute said very similarly, it provided provisions that were very similar to President Trump's executive order. So I wouldn't be surprised if there were further attempts, even if the court rules against this executive order in this case.
So, McKay, for people who don't follow the courts really closely, and as you said, this decision is probably going to come down within the next week. What should they be listening for when the Supreme Court releases its decision?
I think this case is one of those few cases where the issue before the court is fairly clean cut. I don't see a lot of room for the court to, if you'll excuse the term, split the baby and try to find some middle ground here. So if I'm watching the court, I think we're going to see across the news channels the headlines that are either, the birthright citizenship is upheld or birthright citizenship is no longer what it used to be. So I think it's going to be fairly clear when the court does rule what its ruling is.
So I know that you teach graduate students. I want to end with this. Let's take it down to like a high school, middle school civics class, okay? If you had to explain this to high schoolers, to middle schoolers, why this case matters, no matter what the decision ends up being, what's the takeaway you would want folks to remember?
The United States is a constitutional representational democracy. That means that we, the people, a long time ago, ceded some, not all, of our authority in order to create our federal government. That was memorialized in a U.S. Constitution, which represents the rule of law. And the rule of law means that no man or no department or no entity can unilaterally upend the rule of law, and that there are processes that are required in order to change the law. This case is important because it features a very clear provision of the U.S. Constitution and an attempt to change that provision of the Constitution in a way that does not follow those processes. And as a result, this case, I think, should be noted for which direction it goes in that way.
Well, I want to thank you so much for coming on today and talking with us about this. Of course, I'm sure once we have a decision, we would love to have you back on to discuss the implications of that. But as always, really appreciate your time and your expertise in this matter.
Thank you so much, Gemma.
We've been talking with McKay Cunningham, graduate professor and director of the Master of Applied Public Policy program at the College of Idaho. We've been talking about the case in front of the U.S. Supreme Court right now in regards to birthright citizenship. As both McKay and I said, we should have a decision within the next few days on this case. So be listening and watching for that. Thanks so much for listening to this episode of Idaho Matters. And for quick news of the day, start your mornings with our podcast. It's called The Connector, Idaho Daily News. If this podcast has become a part of your routine, can you tap 5 stars and leave us a review? It helps us stand out.
Each story you hear on Planet Money starts with a question. What happens if we refund tariffs? Why are groceries so expensive? At NPR, we stand for your right to be curious because the forces shaping our world can be hard to see. Follow NPR's Planet Money wherever you get your podcasts and start seeing how the economy really works.